Court. I'm Martha Karua, Senior Counsel, appearing for A1 and A2 alongside Arias Lukwago, Proskovia Kunihira, Aaron Chisa, Ms. Ansunduga for A3 is not yet here. If the state may allow me to introduce them, we have Mr. Thomas Jatiko, Assistant DPP.
This is true.
Chief State Attorney.
That is true, my lord.
This matter was fixed for a ruling today, presence of all parties. There is no reason given as why counsel for yesterday is not in court. But since yesterday is in court, what will go ahead to deliver the ruling? This is a ruling on referees constitutional court. This ruling is in respect of a request to court by counsel for A1 and A2 to refer the question of the law to the constitutional court for interpretation. The question as proposed and framed by counsel for A1 and A2 is that whether the court presided over by a judicial officer against whom is a complaint by the chosen person in that court seeking removal, especially where the complaint is pending, is an independent and impartial court. In accordance with the plain and ordinary meaning of Article 28(1) and Article 44(c) of the Constitution. Counsel for A1 and A2 moved the court under Article 137, 3b, which briefly states that where any question as to the interpretation of this Constitution arises in any proceedings in a court of law rather than a field of matter, the court shall, if any party in the proceedings requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this Article. Counsel for A1 and A2 made submissions to above. One said that all the submissions of counsel for A1 and A2 were put into consideration, but briefly they submitted that in light of Article 28(1) and Article 44(c) of the Constitution, there is a complaint pending against the trial judge before the Judicial Service Commission made by A1 and A2 seeking removal of the judge from office. Counsel submitted that there is a need to interpret Article 28(1) and 44(c) of the Constitution. That the question to be answered is whether this court can continue to be an independent and impartial court within the plain meaning of Article 28(1) of the Constitution, bearing in mind that the article cannot be derogated from. That the question is whether, in its plain meaning, the court faced in such circumstances can be or even seen to be independent and impartial, particularly for purposes of trying those people who have brought the complaint against them. Counsel contended that Article 137(5), paragraph 1, paragraph A, gives this court discretion, while paragraph B does not grant such discretion and is mandatory in its terms. Council further submitted that the article is framed in a way that court, while doing its work, may find an issue and make a reference that if any of the parties on whose behalf that work is being done asks it to refer, court must refer. What remains is the framing of the question. Council concluded that this court be pleased to refer the question of law proposed to the Constitutional Court for interpretation. Briefly, Chief State Attorney submitted that before court refers any matter for constitutional reference, it must be satisfied that there is a question of law, right for interpretation. That any matter which is disguised under interpretation, but the actual sense of it is a violation of the human rights, is not a matter that this court can refer to interpretation. He submitted that the application is based on the alleged complaint of the Judicial Service Commission, that there is no copy of the complaint served is intended to assist the process of hearing this matter. In rejoinder, counsel for A1 and A2 submitted that the role of the prosecutor in the court is to charge and present all the evidence and all times afford justice. That the prosecutor is not a persecutor and should always restrict himself to ensuring that the process is fair for all parties. Counsel further submitted in rejoinder that justice is about perception. It needs not only to be done, but to be seen to be done. That judges are human, and the perception of the man on the street is whether, in the instant case, this court will be seen to be fair to the accused persons. Counsel further stated that there is a question of law as to whether a judicial officer whom the accused persons have complained against before the Judicial Service Commission can continue to hear their case, and such a proceedings will be taken to be fair and in conformity with Article 28(1) and Article 44(c) of the Constitution. Counsel still in rejoinder referred to the cases, specifically the case of Professor Isaac Hamilton Ojo versus Uganda, preliminary appeal number 33 of 1991, which relate to the question of perception as opposed to actual bias, and submitted that court does not look at the mind of the judge or when whoever it may be, but looks at the impression which would be given other people. Determination of court. It is now a stated law that references to the Constitutional Court fall under the ambits of Article 137 of the Constitution. Article 137, 5B of the Constitution, under which Counsel for A1 and A2 moved this honorable court, provides as follows. Any question as to the interpretation of this Constitution shall be determined by the Court of Appeal sitting as a constitutional court. 5. Where any question as to the interpretation of this Constitution arises in any proceedings in the court of law other than a field court-martial, the court may, if it is of the opinion that the question involves a substantial question of law, and B, shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this article. Basing on the above article, the position of the law, therefore, is that a reference to the Constitutional Court is subject to determination by the trial judge as to whether there is a question for interpretation of the Constitution. In the matter of Sheikh Abdul Karim Sentama and another, Constitutional Reference number 7 of 1998, the Constitutional Court stated that it seems to us that the trial judge sought that if any party to the proceedings requests a reference to the Constitutional Court, then the court was bound to agree to his request. In our view, the duty to refer the question if a party so requests is subject to a question as to the interpretation of the Constitution arising in the proceedings before court. This is clear from the provision of Article 137(5). It goes ahead to say that, however much a party may request, it cannot have referred a matter that does not involve interpretation of the Constitution, nor can the party give the court jurisdiction which the court does not have by law. See the case of Attorney General versus Milton Obote Foundation Limited and another, Civil Appeal number 7 of 1992. The Constitutional Court has determined that the applicant must go to show prima facie the violation alleged and its effect before a question could be referred to the Constitutional Court. In the Constitutional Petition number 46 of 2011 and Constitutional Reference number 54 of 2011, in the case of Honorable Sambo Kesa versus Attorney General, at page 39, their lordships stated as follows: that both the Supreme Court of Uganda and this court, that is Constitutional Court, have in a way dealt with this issue. In a Constitutional Appeal number 2 of 1998, Ismail Selgo versus Kampala State Council and Attorney General, the rest of their lordships of the Supreme Court expressed no contrary view to the holding of Wamsi CJ, as he then was, who stated that, in my view, for the Constitutional Court to have jurisdiction, the petition must show, and on the face of it, that the interpretation of the provision of the Constitution is required. It is not enough to allege merely that a constitutional provision has been violated. Following the above holding, this court, in Constitutional Reference number 31 of 2010, Uganda versus Gonza Francis, held that Article 137(5) should be read in the proper spirit of the Constitution, that the applicant must go further to show prima facie the violation alleged and its effect before a question could be referred to the Constitutional Court. From the above decisions, it follows therefore that Article 137(5) A and B, the court deciding to make a reference must first be satisfied that a prima facie case exists or has been made out by requesting party, that an interpretation of the provision of the Constitution is required. If the court comes to the conclusion that this is not established prima facie, then no reference should be made to the Constitutional Court, whether under Article 137(5)A or B. It cannot therefore be said that Article 137(5)B takes away the independence of this court. In the instant case, briefly, counsel for the accused persons contend that since there is a complaint against the trial judge before Judicial Service Commission, it is against the spirit of Article 28(1) and 44C of the Constitution for the court to continue handling the case as the judge is likely to be biased and the accused persons will not have a fair hearing. Counsel contended that this arises as the issue that requires the Constitutional Court to interpret the above articles of the Constitution. Therefore, he is called upon to test the validity of the constitutional reference and establish whether there is a question of law that warrant constitutional reference under Article 137, 5B of the Constitution. I have very carefully examined the question of law raised by counsel for accused persons, to wit, whether a court presided over by a judicial officer against whom the complaint by the accused persons in that court seeking removal of that judicial officer from office under Article 144 of the Constitution is pending, especially where the complaint is pending is an independent and impartial court in accordance with the plain and ordinary meaning of Article 28(1) and Article 44C of the Constitution. From following authorities I have cited, I am bound with the same. It is this court's opinion, therefore, that the question of law proposed and framed by counsel for the accused persons for interpretation does not involve a substantial question of law for interpretation of the Constitution. The allegation that there is a likelihood that the accused persons who complained against the trial judge for the Judicial Service Commission will not get a fair trial is an imagination, because Article 28 of the Constitution lays down all the principles of the right to a fair hearing, which court is mandated to observe and cannot be compromised by the trial judge. I have put into consideration the cases referred to by counsel for A1 and A2, that is the case of Professor Isaac Newton of York. However, it is my finding that the authorities referred to relate to the bias, not directly relate to the constitutional reference. It is my view that this court is not satisfied with the question of law framed for constitutional interpretation. In the final result, it is this court's finding that counsel for the accused person have not made out a prima facie question of law to warrant reference to the constitutional court for interpretation. I accordingly decline to refer the proposed question of law to the constitutional court, and I direct that let the matter be fixed for scheduling and pre-taking the so-called